We've got a couple of housekeeping points. All participants will remain muted and without cameras during the presentation, but we'll leave the chat live. So if you've got any questions, just add them onto the chat for us. We'll be monitoring those questions that come through, and then we can address these towards the end of the session. We will also be recording this session, and that will be sent out after the event, and it might also be made available on our website or media channels. Still got a few people joining. Okay, before Maria gets started, I just want to talk to you briefly about the ways in which CFAB can assist you. So hopefully some of you are already aware of the work that CFAB does, but for those of you who need a refresher, CFAB is the UK branch of International Social Service, and we've got access to partners in over 130 countries around the world. We are experts in social work in an international context, cross-border child protection cases, care proceedings that require cross-border cooperation, and overseas placements. If you require guidance and practical support on cross-border children and family cases, then you can call our free advice line, which is available 5 days a week. The number's there on the screen for you. We've got casework services. We provide casework services that include issuing child protection alerts, completing record checks, welfare visits, full assessments. We can also provide pre and post placement support services, family reunification support, and we also have a dedicated legal advice service, which I am sure Maria is going to tell you all about during her presentation. Our training programme can provide you or your organisation with in-depth content relating to international child protection, kinship care, best interest assessments for unaccompanied children and more. And we also offer our International Social Work Certificate, which you can complete in your own time, and this counts towards your CPD hours, and it covers a range of topics such as forced marriages, harmful practices, parental child abduction and international child adoption, amongst other things. The website's full of resources, and there are free fact sheets that you can download, and also available is our International Kinship Care Guide, which is our good practice guide for professionals placing children from local authority care with family abroad. So we would ask that after the session you do visit our website to find out more about how CFAB can support you with your cross-border cases, and please do not hesitate to call our advice line if you do need any assistance at all. So that's probably enough from me. I'll pass you over to Maria now. Maria Wright is our senior legal advisor, and she's going to take on our lunch and learn session, arranging assessments of families overseas. Thank you, Maria.
Thank you so much, Angela, and I hope everyone can see and hear me. And if you have technical issues, please don't worry, because there will be a recording available of today's presentation. So my name's Maria Wright. I'm the Senior Legal Advisor at Children and Families Across Borders. I'm also a doctoral researcher finalising a study into care proceedings with an international element. And I'll be talking today about assessing family members overseas. This is an introduction and it won't cover everything, but what we hope is that this will be the first of several lunch and learn sessions, and that you'll be able to take something from the session today. The focus will be on the assessment of family members overseas as potential kinship carers for children in respect of whom there's been some form of court-based child protection intervention, such as care proceedings. And I apologise in advance if I slip into using terminology from England and Wales, and that's not the area that you practice in. I apologise, because that's my area of practice, but I hope that this presentation will offer some insights which are capable of broader application throughout the UK. And hopefully, if we have time, I'll be taking questions at the end and would invite you to put them in the chat. So Angela has outlined some of the services that we offer at CFAB, and I won't go through them again. But for today's purposes, it's worth noting that most of CFAB's partners overseas are able to conduct assessments of family members for use in proceedings in the UK. We also work in partnership with the Welsh Government to undertake cooperation functions on their behalf under the 1996 Hague Convention. And I'll be returning to this later, but this aspect of our work has been really valuable in increasing awareness of the way that different countries operate. Anyone here today who has previous experience of the process of assessing family members overseas will know that it can be very challenging. And really, I think that this challenge stems from two main sources. Firstly, the fact that our domestic regulations and frameworks for assessing family members as potential carers for vulnerable children are not designed with cross-border relationships in mind. And so our domestic scheme, as it currently stands, does not necessarily account for the distinct issues that might arise where a family member is living overseas and the child is living in the UK. Secondly, there is a huge global diversity in approaches to social work practice, child protection and family law. And this can include a variation in thresholds for child protection interventions, as well as the extent to which kinship care operates as a regulated state-based response to child maltreatment. So in the UK, kinship care, formal kinship care is generally a prevalent response to child protection interventions, and it's highly regulated. And this tends to be the case in high-income countries. However, in many countries across the world, kinship care is a widespread but informal practice. And the legal structures for formalising kinship care arrangements may be more limited or maybe non-existent. So what we're left with is trying to fit cross-border relationships between children and family overseas into a domestic scheme for regulating kinship care arrangements, which was not designed with those relationships in mind, against a broader context of huge global diversity in state-based child protection practices. And when thinking about this challenge, we need to think about remember that when we're thinking about a child's placement overseas with family, we're contemplating a child growing up outside of the UK in an environment which has its own norms and values, as well as distinct aspects of civic life. And it's really difficult to gain an insight into those aspects of a child's future care without knowledge from professionals in that country. So if you've not already done so, I would really urge you to watch CFAB's International Child Protection Lecture from last year, and in particular, the presentation from Michael Nawoy, one of our inter-country social workers, who is a qualified Nigerian and UK social worker, who spoke about his prior experience of assessing family members in Nigeria for the purposes of UK court proceedings, as well as other aspects of CFAB's work where local practitioners are able to provide really valuable insights into family life in other countries, which can inform decision-making for a child. And so how do we navigate the challenge of trying to obtain an assessment from overseas, which gives us those really important insights about the country and community where the placement is contemplated, whilst at the same time trying to meet the requirements of our domestic legislation and regulations for these placements, and to enable a court to arrive at a decision about what is in the child's best interests. And here I've tried to summarise some of the guidance that's available on this issue, with links that you can access later if you wish to, when the slides will be circulated. But what I'll be returning to throughout today's presentation arises from the best practice guidance on special guardianship, formulated by the Family Justice Council in England and Wales, but which I think is relevant to all UK jurisdictions, which is the need to consider how assessments can be carried out in a legally compliant and culturally relevant manner. And legally compliant in this context, I think, can mean compliant with the law in the UK and the country where the placement is contemplated, as well as being consistent with any relevant international legal instruments as well. The DFE's guidance on working with foreign authorities also emphasises the importance of assessments being culturally relevant, and that this may require assessments from overseas. And the case of re-KTNU, I would also refer to, is a really helpful judgment of Recorder Samuels, which outlines in great detail the practice issues which can arise in a cross-border case. So this was a case which concerned a potential placement in Bermuda, and the judge noted that in order to obtain something legally compliant in terms of assessment, it may not be practicable for a single professional to undertake all the work, and multiple methods may need to be used. Finally, I would refer to the International Kinship Care Guide, which Angela mentioned at the outset, formulated by the Cross-Border Child Safeguarding Working Group, which contains a lot of information about how to obtain an assessment which is legally compliant and culturally relevant. And the Family Rights Group's Guide to Initial Viability Assessments also has a section on conducting initial viability assessments in cross-border cases. But assessing an overseas carer in a legally compliant way, I think, doesn't just mean obtaining an assessment which complies with domestic regulations and criteria. I think it also means thinking about the legal requirements of the other states where the child will be placed and the impact of international legal frameworks. And in this context, I wanted to talk about the 1996 Hague Child Protection Convention and how it can be relevant to assessing family members overseas. So for those who may be unfamiliar with this instrument, it's an international convention which applies between the UK and a number of contracting states globally, which governs cross-border aspects of children's proceedings, including both private and public law proceedings, but not adoption or measures preparatory to adoption. The convention serves four functions in care proceedings, but three that I will speak about. Firstly, it lays down rules about jurisdiction, which tell us which countries' courts are responsible for making decisions about a child with international connections. Secondly, it provides a framework so that court orders about a child made in one contracting state can be recognised and enforced in another contracting state. And thirdly, and importantly for what we will talk about today, the Convention supports cross-border cooperation in children's cases through centralised institutions called central authorities. Every contracting state to the 1996 Hague Convention has a central authority, and the UK has central authorities for England, Wales, Scotland, and Northern Ireland. And the function of central authorities is to cooperate with each other and to promote cooperation between competent authorities, such as courts and local authorities who are competent to make decisions about children. There are a number of specific cooperation provisions in the 1996 Hague Convention, which I will not go through today, but which can be relevant in cases with an international dimension to share and exchange information. But this is the core function that I will be speaking about today. The Convention also has applicable law provisions, but I won't be speaking about those today. The contracting states to the 1996 Hague Convention are listed on the website for the Hague Conference of Private International Law, and it's a list which is constantly changing as new states join. But all EU member states are contracting states to the Convention, as well as there being a number of contracting states outside of the EU, such as Russia, Australia, Turkey, Morocco. So if you have a case involving one of these countries, you may find that the 1996 Hague Convention is relevant and that you might be able to engage in cooperation with that country through the relevant UK central authority. And one of the ways the 96 Hague Convention might be relevant is that it may be possible to obtain an assessment of a family member overseas via the central authority designated by the 1996 Hague Convention. There is a diversity here, as some central authorities will not accept requests for assessment of family members. So our recent experience with Ireland is that it's instead necessary to obtain an assessment through an Irish registered independent social worker rather than going through the central authority. Whereas others, such as Poland, require that assessments of family members in their country go through the central authority. So there is a diversity in the way that different states approach this issue of assessment through central authorities designated by the 96 Hague Convention. What I've tried to do here is to explain how the process of obtaining an assessment through this method works in practice. So if we take the example of care proceedings in England, where there's a need to assess a grandmother in Poland, the local authority would send a request for cooperation to the relevant UK central authority under the 96 Hague Convention, which will be ICACU in England. That request is then transmitted to the Polish central authority, who in turn transmit it to the relevant local competent authority where the prospective carers are living, which would usually be the statutory child protection agency. They then prepare a report and it's transmitted back via the central authority to the local authority. And so the good thing about this process, about using this method, is that it's entirely conducted in accordance with local law and procedures in the requested state. It's also usually free, and assessments will be culturally relevant as they're steeped in the environment where the placement may occur. What you will get back from this process will vary considerably. So some assessments may be a couple of pages, some will be more in-depth and incorporate a home visit and record checks. Some countries might agree to answer additional questions following receipt of, if you receive a assessment back and there are additional questions, some countries will respond to those, others will not. So there is some variation, but the important consideration here is that some contracting states to the 1996 Hague Convention require that they be consulted prior to a child being placed in a formal kinship care arrangement in their country. And that requirement stems from Article 33 of the 1996 Hague Convention. And so if the overseas competent authority has completed the assessment using this method and it's positive, it's likely that this will inform the Article 33 process. And I just want to mention Article 33 of the 96 Hague Convention in a bit more detail. So this provision states that when considering placing a child in another contracting state to the 1996 Hague Convention, it's first necessary to consult the overseas competent authority, a request which can go through the central authority, and set out the reasons why the placement is being proposed. And they will then arrive at a decision as to whether they will consent to the placement and whether it's in the child's best interests. It's not always clear when the Article 33 consent procedure needs to be followed because different countries take different approaches. So the actual wording of the convention is that it's required for placements in a foster family, kafala, which is a form of alternative care used in countries which adopt or are inspired by a Sharia law system, institutional care or analogous institutions. However, we do know that there are a number of countries who do require the Article 33 consent procedure to be used, for example, for placements under special guardianship orders with kinship carers. So it's important to bear it in mind. The other issue associated with Article 33 is that if the consent procedure is not followed, this can potentially be a ground for the order placing the child in that country not being recognised. So it is quite an important consideration. And we have linked here a number of resources, and we have also developed our own resource on this provision because it can be quite tricky. CFAB can also provide overseas assessments. So CFAB has a range of partners from ISS network members, charities like CFAB. Some of our partners are statutory agencies for child protection. Some are independent social workers. Increasingly, we have a network of overseas independent social workers who are also trained and qualified in the UK. So they're able to produce the types of assessment that you might expect in UK court proceedings. We have partners globally, so not just in 1996 Hague Convention contracting states, but in a number of countries across the world. And because these are assessments conducted by professionals in other countries, they are culturally relevant assessments. What's received back, again, like with a request through the central authority, will vary. Some of our partners are able to produce very comprehensive assessments. Others will be less full, maybe shorter, may focus on different areas than you might expect in the course of a domestic assessment, may omit certain matters and concentrate heavily on others. And so we try and be transparent about this at the outset based on our previous experience of our partners. Depending on who our partner is, if the placement is in a 1996 Hague Convention contracting state, it may also be necessary, if the placement is going to go ahead, to go through the Article 33 procedure, which I've just spoken about. That's certainly the case for Australia, for example. If a request for assessment is made of our partner in Australia, they will provide an assessment, and then if the placement is going to go ahead, the local authority would need to inform the Australian Central Authority via the UK Central Authority and request consent to that placement under Article 33. We also at CFAB have a lot of country-specific knowledge, and more recently we've developed our legal advice service so that we have legal partners in other countries who can prepare expert reports to support the legal framework for placing the child in the relevant country. So, for example, we have a recent case where our partner in Nigeria conducted a very full assessment of relatives as potential carers for a child based in the UK, which was positive. And our legal partner in Nigeria was then able to provide an expert's report which set out the relevant family law structures and applications that might need to be made in Nigeria for the carers to have parental responsibility and custody of the child. So that is one of the additional services that we can offer at CFAB. Other than using the central authority or CFAB to obtain an overseas assessment, there are some other methods which might be used, potentially in conjunction with some of the methods already discussed. And one of them is that it may be possible to establish direct cooperation with the relevant statutory agency overseas responsible for child protection to obtain an assessment. We've seen that happen in some cases. Social workers, UK-based social workers travelling overseas to conduct assessments. It does still happen. We do see it happen. And really, it's understandable in a way that there would be a wish for a UK-based social worker to be the one conducting the assessment because they know the child and they have a specific insight into the family dynamics and situation for the child. But there are a number of issues to consider about this. And the main one is really around the legality of a social worker practicing in the other country. So to take the example, we have been informed by our partner in South Africa that it's illegal for a social worker to practice in South Africa without being licensed and regulated by the relevant professional body. So there can be serious implications in some countries. There are also issues around the ethics of undertaking an assessment in this way and risks for a UK social worker of doing this, as well as the importance of having contextual knowledge to apply to the assessment. And so we have developed a fact sheet on these issues, which can be accessed via the link, which also sets out some of the steps that might be taken if it's an option that is being explored. Another method that we see is a potential carer travelling to the UK for further assessments. And this can be useful as it can facilitate an observation of the child and their prospective carer and their relationship, albeit in an environment which may be quite different from the environment where the placement will actually take place. It won't always be possible for practical reasons for a prospective carer to travel to the UK for this purpose. And in particular, we've seen potential carers having real difficulties in accessing visitors' visas to enter the UK to undergo further assessments. And so if this is a method which is being contemplated, we would suggest that it's one that is explored at an early stage so that those issues can be dealt with as quickly as possible. Remote assessments we have seen increasingly post-COVID, and the challenge here is that they may not capture the local context for the assessment. And furthermore, it may not be possible to verify precisely what is being seen on the assessment through remote means, if that method is being used in isolation, but we do see it being used alongside other methods. So I hope what I've shown is that different methods have advantages and disadvantages in terms of securing an assessment which is both legally compliant and culturally relevant. And to achieve that goal, it may be necessary to use more than one method to assess a prospective carer overseas. And I'm going to outline in a little bit some cases where multiple methods have been used in a very effective way. But before I do that, I have developed an overview of the overseas assessment process. And one issue which I've not discussed yet is the importance of identifying a child's nationality and potential immigration status in the other country where the placement is contemplated right at the outset of the process, right at the outset of proceedings, or at a pre-proceeding stage if possible. And the reason for this is that if a child cannot permanently reside in the other country, it may be that the only way to make the placement happen is by way of inter-country adoption. So if we take the example of Australia, if a child is not an Australian national, they may be able to access a visa, they may be able to obtain a visa to live in Australia if that's the court's decision with a kinship carer. But the visa category which is being used may only be possible for certain relatives to be able to sponsor that visa. So if the placement is with a more distant relative or a godparent, for example, it may not be possible for that relative to sponsor the visa for the child to live there permanently. So this is an issue which needs to be explored before the assessment is actually conducted, because what we do see sometimes is kinship style assessments being conducted and they are positive. And then when looking at the practicalities of the child's placement, it transpires that it would not be possible for the child to obtain an immigration status in the other country, which then means that a lot of time has been wasted looking at an assessment which is not able to practically proceed other than by way of inter-country adoption, which would resolve the immigration issues. The other issue around clarifying nationality and immigration status is that it may also impact on the child's ability to access local services in the other country if they're not a national or if they don't have permanent immigration status in that country. So it can be relevant also to access to the kind of post-placement and lifelong services that the child will need if they go and live in the other country. If the child can live permanently in the other country from an immigration perspective, the options for assessment and legal framework applicable depends on whether the other country is a 96 Hague Convention contracting state. If it is, there's potentially the option of using the central authority for an assessment and the need to consider Article 33 of the 1996 Hague Convention. in addition to any of the other methods that I've outlined. We will not have time to cover the legal frameworks for placing children overseas today, but if the child is moving to a 1996 Hague Convention contracting state, this is also relevant to the recognition of any order made at the end of proceedings. So as I said at the outset, the 96 Hague Convention contains rules for the mutual recognition of court orders concerning children between different contracting states. And so there may be the possibility of the final order placing the child with the prospective carer in the other contracting state being recognised in that country using the 96 Hague Convention. This is not always the right option for the child because they may need a domestic order, but it is a possibility and something to bear in mind. So I'd like to finish by outlining two examples of cases where using multiple methods to obtain an overseas assessment worked very well. So the first was a case involving a potential placement in Italy. The child was in care proceedings and had been placed in an interim foster care placement under an interim care order. The local authority sought an assessment through CFAB of the child's paternal aunt. And CFAB's partner in Italy is an independent social worker who is qualified in both Italy and the UK. And so she produced a very comprehensive assessment which contained all the relevant appendices as well, record checks and evidence of income. The local authority in this case also requested an assessment through the central authority to support the Article 33 process. So they made a request for cooperation through the central authority in England, which was transmitted to the Italian central authority and then to the local competent authority responsible for child protection. So they undertook their own assessment as well. And that assessment was more brief, but it was positive. And when it was clear that this was a placement which was almost certainly going to go ahead, or very likely to go ahead, the local authority made an Article 33 request and the Italian competent authority consented to the placement because they had already determined that the placement was in the child's best interests, having undertaken an assessment themselves. The child was placed in Italy and the aunt was supported in this case to apply for an order there which gave her access to support from the local statutory agency. So this was a very good outcome, and it's not always this simple, but this is an example of a case where it has gone right. I'm sure you will all have experiences and come into contact with cases where it has not been so straightforward by any means. In another case we had involving Malta, CFAB's partner there is the statutory agency. And in this case, they conducted a very extensive fostering assessment of the relative who was being put forward as a potential carer for the child. And that included record checks and home visits, and the carers were also able to go on the relevant fostering course, which was provided by the statutory agency. They also travelled to the UK for a further assessment by the UK social worker. So there was ultimately a special guardianship assessment in this case. And the CFAB were able to then facilitate a meeting between the Maltese and UK local authority to support that assessment process. The child was ultimately placed under an SGO. So this had a very positive outcome for the child. So before I take some questions, I'd like to highlight our legal advice service, which can provide legal support with some of the issues I've spoken about today, as well as facilitating expert reports from lawyers overseas. So you're welcome to contact me on the email given if you have any questions or legal issues that you would like to ask me about. And with that, I would invite you to put any questions that you'd like to pose. I'd also invite you to answer the poll, which Angela will be posting in the chat. And more generally, it'd be really great to have some feedback from you and suggestions for future sessions in terms of what you would like to see. I have to say we've been really blown away by the response to this session. We've had an unprecedented number of people interested in attending. And so I think that just speaks to the fact that these are really difficult cases and really difficult issues to manage, and that so many of us will be experiencing cross-border issues in our practice as the population of the looked after population is increasingly diverse. And so I will see if I can answer some questions. Okay, so one of the questions is that the 1996 Hague Convention in reality requires an added layer process for recognition, unlike EU instruments from which we no longer benefit. Is there a consolidated information about whether the 1996 Hague Convention countries go through the process for recognition or declaration of enforceability? I think this would be really useful, same in relation to advanced recognition. So I think that's a really important question. And I think there is, what would be really helpful is if we had access to publicly available information about how each 1996 Hague Convention contracting state operates in the context of cross-border child placement. And that could include information about the recognition and enforcement procedure in that country. It could include information about whether the Article 33 consent procedure is required for certain categories of relatives or only close relatives. I think that would be a really valuable resource. At the moment, to my knowledge, that resource is not available, but I think that UK central authorities have a lot of experience of certain countries being involved in these cases. So it's usually, from my experience, it's based on prior experience with the country in question. But I think that access to this centralized resource would be really valuable, and I would like to see it. I've also been asked, is it usually the social worker or legal who approach the central authority to obtain Article 33 consent? I don't think it matters who completes the request for cooperation form. There's a form that needs to be filled in, and hopefully I've provided the links to it. It just says the local authority, but we do tend to see that form is completed by legal, and that might be because on the form you have to specify which article of the 1996 Hague Convention the request is made under. So there's a legal dimension to submitting the request for cooperation. But we do see requests for cooperation being made by social workers as well, because sometimes these requests are made outside of proceedings, at a pre-proceeding stage, to obtain background information on a child who's previously lived in another country. I will just try and take a couple more questions. So one of the questions I've had involves somebody has a case involving relatives who live in Iran who want to be considered as a prospective carer. Have CFAB worked with Iran? I'm sorry that I can't remember what our whether we have a partner in Iran and the extent of their work. And so this would be a really good question where you might like to contact CFAB's advice line and speak to one of our caseworkers, and they will be able to tell you precisely what our services are like there, and if we've had any previous experience in that area as well. Let me just see if I can take one more question. So I've been asked, are there any plans for CFAB or ISS to return to Afghanistan given the numbers of unaccompanied asylum-seeking children? Are there any alternative agencies? Again, I'm sorry, I can't remember what our partner situation is in Afghanistan. I know that previously we have not had a partner there. We do encounter a lot of cases involving unaccompanied asylum-seeking children with links to who've sought refuge from Afghanistan through our post-placement support projects and family reunification projects that we offer at CFAB as well. So again, I think this would be a really good question for the caseworkers at the advice line, and I'm sorry that it's not one that I have that I'm able to answer, but hopefully someone will be able to. And so with that, I would like to thank everyone for attending, and I would like to reassure you that the slides will be shared and that recording of today's session will be shared. And if anyone has any questions that they were not able to ask or which I missed, I'm sorry, but please do feel free to email me. And I would just ask, if you don't mind, to provide us with a bit of feedback. That would be tremendously helpful. I hadn't really appreciated before working in the charity sector how important feedback is in terms of measuring the impacts of our work. And so I often would not provide feedback at the end of training sessions. I completely understand if you don't have time, but if you're able to give us a few comments or feedback for future sessions, that would be so, so helpful. Thank you. And with that, I will wish you a pleasant day, a lovely afternoon, and hope to see you all soon. Thank you.
Thank you very much, everybody.